the first to know. Nsem-Pii TV.
Going into 2024 elections, at the back, Ghana for an electoral commission for person better. Say, citizens be of other nations or more border towns. Yebetimi edi omo ababi brim. Na ometimi akwakoto aba ama a different political party. The NDC has been largely accused of using sa border towns wa flower borders ne niemana and amakasa omudi to police bibrim eto aba ema NDC political party omuvi anoma sanso akọ back to the nation. Na no na necessity a lot of events. Electoral Commission forecast only 144,000 persons from the voters register. No na sa clean up exercise na air cost no case be ko PM Supreme Court. Na omoka say obi kwa ko register for voters ID documents obetimi use or the proven citizenship one Ghanaian passport and the Ghana card. Na NDC for the court to say omonfa birth certificate in count Ghana for nko be brain him say birth certificate. So when your birth certificate 50 Ghana cedis na onsa aka yen verify hwe you to be now na ya print copies e dey abroad. The birth certificate ehun nya den bibiri wo Ghana ntina Supreme Court so mutina sa case so no decide say whether birth certificate no ebetimi approve obi citizenship and I say improve obi citizenship. And na Justice Tukono Gertrude Tukono, the current Chief Justice, that's a case so say a birth certificate is not a form of identification. It does not establish the identity of the bearer, nor does it link the holder with the information on the certificate. Quite obviously, it provides no evidence of citizenship. Supreme Court verdict or the buyer. And no, now, former current president, His Excellency Nana Addo Dankwa Akufo-Addo appointed new Supreme Court judges. Call Supreme Court and Honorable Ato Forson, minority leader of the NDC, Asia as Supreme Court, or the Nanono Bishia Chief Justice and a Supreme Court verdict or moment earlier. No busana about birth certificate, Ghana card identification, citizenship. Sending your umbitimi any access to voters ID. Na amansan for net is a Supreme Court for no or moon for ruling papa any day ember. And na Supreme Court nominee say, Massa, me start a law no na enye ne. Inti yenkoti Ato Forson and the final Supreme Court nominee on any din komo during the appointments committee meeting or vete Supreme Court for nominees.
Thank you for the clarification.
So you may have to
thank you very much.
Get GRA to do the needful.
Thank you for the clarification.
But finally, in an answer to a question posed by Honorable Kwame Abuja, you had said that if you are asked to prove your nationality, you will use your passport. You are among the privileged 1% of our society, so you have your passport. Assuming you come from my constituency and you are not a Supreme Court judge and you are somewhere working as a farmer and you don't have access to a passport, what will you use as evidence to prove your citizenship?
You see, the reason why I was asked to having, which I didn't want to do, have a banter with honorable member, was that this issue arose within the context of what the issue that you are raising now. It arose within the context of what you would use to identify yourself for purposes of getting registered. For purposes of getting registered in the voters register. If you read the Jibasi case and you look at the issues that were set down, you understand what I'm saying. This issue arose within the context of what you would use to identify yourself for purposes of getting yourself registered in the voters register that they were compiling. And the court made it very clear the things that you will need to prove. The court made it very clear the things that you will need to prove. If you read the judgment of court very clearly, it enumerated the things that you will need to prove, to identify who you are. And that was the main crux of the case, to identify who you are for purposes of getting your name registered within the voters register. So that is why it is difficult for me to extract the statement that you are making from that case and, as it were, defend it as a principle of law. It's difficult for me to do that. It's difficult for me to do that. Thank you.
There is a decided case, Olympio versus the Republic, and I'm sure you may have read it as a very astute judge. The context of what we are discussing, how do you position that?
I think the Olympio case, we read it in second year constitutional law. That was almost 30-something years ago. I may need to refresh my memory on that. Thank you.
Mr. Chairman, let me say that Justice Nanayao Daku Asare, I have to say that I like his composure and the way he answers the question throughout the vetting. I mean, it's important I put that on record. And we've vetted people, but I like his composure. And, but the issue of birth certificate, I'm not convinced. Not at all. Mr. Chairman,
thank you very much.
Before we leave here, again, we don't have feedback from the National Security and the National Investigation Bureau, the police, the criminal department, CID. So it's difficult for us to take a decision on your matter until we get that information. But I say this because we are vetting you for a position, to be considered for a position as a chief.
Have regard to the concept of accessible justice and then the affordable justice.
Thank you, Mr. Chairman. I do agree with you, and I'm on all fours with honorable members' views about accessibility of justice. I know for a fact I have actually started meetings with the current DG where this matter has been come up, and I know that it is being addressed. That's what I can say. As to how it is, I cannot probably, I don't have a permission to, but I know it is being addressed. It is a matter that is being seriously addressed. Thank you.
Thank you very much, Mr. Chairman. Let me grab your CV once again. Justice Yao Dakwon Asare. Good afternoon.
Honorable Chair.
Congratulations.
Thank you.
Let me first refer you to your CV, page 3. 3 of 7. 3 of 7. Employment history. Line 2. From 1st of February 2023 to date. University of Ghana School of Law. Guest lecturer. May I know if you are paid for performing this function?
Thank you, Mr. Chair. Since February 2023, when I received the offer of appointment, we have not started giving lectures. I have not given any lectures, so I have not received any salaries. I got information from the Dean of the Faculty of Law that we'll probably be doing that. He was suggesting December, because I come from Kumasi to give these lectures. He was suggesting December, but I indicated to them that because of what was ahead of me, if we could be rescheduled so that others can take their part before me. So I have not received any salary from the University of Ghana. Thank you.
Do you have to obtain a permission from the Chief Justice before you engage in a lecture of this nature or engage in an office of profit?
Yes, the Chief Justice is aware, except that these lectures are taking, it's a Ghana School of Law master's program. So we take, I think it's from 7 to 9 in the night. Anytime that we have to take it will be from 7 to 9. That is the impression I get. It is not during the day, so it does not conflict with my normal sittings at all.
My question is, do you have to take permission from the Chief Justice before you engage in an office of profit?
I think that from our code of ethics, yes, the Chief Justice has to be aware if you are going to be appointed as a guest lecturer for the University of Ghana School of Law for practical and realistic purposes, yes. And out of professional courtesy, if for nothing else, she must be put in the know.
Have you obtained permission from the Chief Justice?
If you are asking about the written permission, no, I have not obtained a written permission.
So, do you think it is right as a certain judge of that caliber, Court of Appeal, to, I mean, regardless, I know you said that you may be doing it in the evenings and all of that, but your job is such that sometimes in the evening you have to write judgment and go through some research, and I mean, I can understand the involvement of the kind of work you have to do at that high level as a Court of Appeal judge. Do you think that the performance of your functions as a Court of Appeal judge and the work as a lecturer will not conflict in any way, and that the Chief Justice must be written to, and officially the Chief Justice must write back to you to accept or not?
No, thank you, Honorable Chair. As I indicated, it does not conflict with my sittings. And every Court of Appeal judge knows that our work is 24. Our work, we work like almost every time. And the advantage with being a lecturer is that it helps you really sharpen your tools as a judge. It helps you, seriously, it helps you sharpen your tools. You do more research. It makes you broaden the scope of your knowledge. It is beneficial, and I think it's even beneficial for the judiciary. And our code of conduct, once it doesn't conflict with my sitting and doesn't conflict with the discharge of my duties, I don't see where I can be said to have fouled the law. Thank you.
That I agree, that teaching sometimes sharpens you. But let me ask again that I've heard so many times from legal practitioners and other people that the Supreme Court is a policy court. Do you agree to that?
I agree that the Supreme Court is a policy court. That is true.
Why is it a policy court?
You see, when you look at the jurisdiction or the jurisdictional heads of the Supreme Court, and you look at the way it is structured, the Supreme Court, even though it is the apex court of a land, I see it more or less as a fountain stone from which the entire justice delivery system in our country springs. So the Supreme Court gives direction to the entire justice delivery system in this country. And you realize that most of the decisions that the Supreme Court will give are decisions that are based on construction of or interpretation of maybe constitutional documents, or putting an interpretation on a certain state of fact. And in so doing, they are always, you see, the law is underlined by policy. That is something that you must never forget. The law is always underlined by policy. So any apex court that is, as it has the prime duty of being the apex court has to be a policy court. That's the way I can put it. Because the law primarily, by its nature, is driven by policy. You can be there.
So, Chairman, may I know if there is any form of limitations, legal limitations or structure to be able to guide the Supreme Court anytime they act as a policy court? Is there any limitation or any legal framework to guide the policy of?
Chairman, you see, for one, I'm not there yet. I've never sat in the Supreme Court, and I don't know how they articulate their decisions as far as policy-driven decisions are concerned. So I will have a difficulty answering this question. I'm sorry.
Honorable nominee, may I ask from you, what is your perspective about the current state of the judiciary? Is it a judiciary that is doing well, or you believe that there are some challenges that you think that we can improve on?
Thank you, Mr. Chairman. I believe that being a human institution, it cannot be 100% perfect. But I also sincerely believe that we are doing all we can to not maybe get to the perfect ideal, but we are doing all we can to be as good or as perfect as possible based on the circumstances that if I say we, I'm referring to the Supreme Court, of course. I'm not part of it yet. But the Supreme Court is doing all it can. Or if you want me to say the judiciary is doing all it can to attain to as perfect a level as possible. Maybe we are not there yet, but we are going to get there. That I can assure you.
Do you think there are any form of challenges after working with the judiciary service for so many years? You think there's something you would think as a major challenge that the Ghanaian public should be made aware of, and Parliament in particular, so that going forward we can do something about it?
So during the course of this interaction, I think I mentioned a few of the things that I would want. For example, I would want to see more courts built. Seriously, I want to see more courts built, more judges employed, so that the workload can be handled and handled more efficiently. I would want to see maybe legislative intervention in our rules of court, especially regarding interlocutory appeals and those other things. I would want to see our e-justice system maybe consolidated to such a state that it will become nationwide. It will become nationwide with resources from Parliament and the executive. I think we can get to that stage. Thank you.
Are you by extension saying that you would wish we appoint more Supreme Court judges?
Mr. Chairman, appointing more Supreme Court judges, I don't know whether that is the answer to. I think that the answer to the workload that overwhelms the Supreme Court may lie more in taking a second look at its jurisdictional heads. Taking a second look at its jurisdictional heads, not necessarily appointing more chief justices. It may come to a time where, yes, it may be necessary to appoint more chief justices. But for now, the settled practice is that, Supreme Court judge, maybe I'm getting tired. The settled practice ranges between 14 and 15. Yes, like I was saying, the settled practice ranges between 14 and 15, and that is where we are now. And I think that even the Supreme Court has, as it were, given its blessing to this settled practice. If you read the GBA versus Attorney General case, it's a settled practice that the Supreme Court has given its blessing to.
Please, do you have a copy of your tax clearance certificate with you? Let me.
Yes, I think I have it on my phone.